Hey everybody, I hope you're well. It's another wonderful day. Sun is shining, it's nice and warm, and we're up and over 30 subs. So if you're new here, hello! And if you're not, welcome back. So if you listening right now, who here likes civil procedure? Because that's what we're going to be talking about. It's Erie Railroad v. Tompkins. Sort of that first intro case when you want to talk about diversity jurisdiction in law school. So before we hop into the facts of the case, it's probably going to help to know what the hell diversity jurisdiction is. And basically, to get into a court, you have to have a couple of prerequisites. Things like standing, ripeness, and jurisdiction. Now, if you're interested in me talking about those other things, like standing and whether it's moot or not, leave me a comment down below and let me know. And if anyone's actually interested, I can do a video on those concepts. So, for jurisdiction purposes, that's basically which court has the right to hear the case. Now, you can have the situation where that's in question. And one way to answer it is to go into the federal courts, even if on a state issue. So you can have a citizen of, say, Pennsylvania and a citizen of New York, as we have in this case, two different states. Who has the jurisdiction? It's the feds. The federal government then can take jurisdiction of that particular case. Now, which federal court gets it is a different discussion, but for the basics of diversity jurisdiction, you can think of it as citizens of two different states going to the federal government to resolve the issue. So how is it that Harry Tompkins ended up in court in New York? Well, he's a Pennsylvania citizen, and about 2:30 in the morning, back in July of 1934, he was walking back to his house. Now, as he's walking, he's going along the side of one of the old railway lines, right? So if you've ever traveled by train, you'll see oftentimes they have these worn paths that go along the line, and often that's because people will just travel with the trains. So he was walking along one of these paths, and he got hit by, well, the train. The allegation, at least, was that he had been struck by this unsecured door coming off this train. In doing so, it actually crushed his right arm, and he ended up losing it. Obviously, he's rather unhappy about this situation, and so he filed suit against the railway line that owned the track and the train for negligence. Only instead of suing in Pennsylvania, he sued in the federal court in New York. Why? Because Erie Railway was actually incorporated and as a result was a citizen of New York, which is how he got his foot in that particular door. Now, it's going to matter that he's the one, obviously, that filed the suit and which venue he chose, and the court addresses it later. Now, we get into an interesting discussion in the facts of the arguments here. So Tompkins was making the argument that he had a license, he had a right to be on that land, to be walking down the path, because it was in common use by the population. And as a result, it was incumbent on the railway to give him a standard of care due to someone that's supposed to be on the property. Now, Erie made a different argument, the railway line. They said no, he was a trespasser. He had no right to be there. And because he was a trespasser, he had to show that the railway was grossly negligent rather than just negligent. Now, the difference is that in gross negligence, the behavior has to be willful and wanton. Now, why does this matter? It matters because in Pennsylvania law, where the accident happened, Tompkins would actually be a trespasser, which is what Erie is arguing. But if you remember, Tompkins didn't bring the case in Pennsylvania. He brought it in New York. And the basic argument is that it belongs in the federal court. There's a diversity of citizenship. And in the federal courts, he was making the argument that this was a general law issue. And as a result, the federal government had a lot more discretion on what they were going to do. There was a concept floating around of a common law at federal government level rather than at the states. As a result, the federal government could choose to do what it wanted in this case. And what they chose to do was to award Tompkins $30,000 for damages, and that award was upheld at appeal on those same arguments about general versus the local law from Pennsylvania. In this particular instance, the court found in that discretion that where people made use of a walkway in an open way without objection, so you didn't try and hide the fact that you were skittering along the line, it ended up creating a duty of care owed by the railway to the people that used that walkway. And as a result, Erie Railway violated that duty when they did not properly secure the train cars going down the line. In getting to the Supreme Court, Erie's basic argument, the railway, was that the Federal Judiciary Act of 1789, and yes, they went back to 1789, said that in a case of diversity jurisdiction, it's actually the law of the several states that applies. There isn't some concept of a common law at the federal level for the judges to apply. Now, the several states, if you haven't heard that particular term, just means the individual states themselves, or the local law. So all of that being said, now we're at the Supreme Court. And what they did is first turn to the prevailing case at the time, the controlling case, and that was Swift v. Tyson. And in that particular case, they said that federal courts exercising diversity jurisdiction didn't have to apply the unwritten law of states as declared by the highest court in matters of general jurisprudence. Now, what is unwritten law? That's what we call common law. So there is statutory law, the stuff that's actually written in the code books. Often you'll see little citations for it on street signs. And then there is the common law, which is what you get in the cases that we've been talking about. It's things that judges hand down in decisions and then bind future decision makers, and it builds and it builds and it builds. But the laws that are in those cases, they're not written down as explicit rules in the statute books. Now, the general reason that the court in Swift found this is they were looking at the same 1789 Act, only they were interpreting it to mean that if it was unwritten law, then the federal courts weren't bound by state law. They could do basically what they liked in this new federal common law. The court in this case said no. They actually went and found the original 1789 document and found out that the interpretation that the courts had been using, allowing for this federal common law, was wrong. They had misread the act. 1789 actually said you're supposed to use the local law. There's no ambiguity in the language. The judges had just been doing it incorrectly. And so following the language in this Judiciary Act of 1789, the court was pretty clear. In instances where the court has jurisdiction because of the diversity of parties and there's a matter at play, you apply the local law, whether it is written or unwritten. There isn't a federal common law that gets to supersede. Then we get into everyone's favorite policy discussions. The court took a look at what the Swift case, the Swift doctrine, was doing to the actual judicial process to see what was happening and whether it was a good thing. And basically they said no, it's really not a very good thing. The benefits that people thought would occur from having a sort of universal federal common law didn't occur. There was some hope there would be harmony across the districts, harmony across the circuits. That didn't happen, largely because the states just kept applying their own laws as they saw fit, and so you end up with this disharmony between the different districts, and particularly between the states applying their own law and the federal government trying to apply that law. And on that point specifically, it ran into a big problem, and that problem was equal protection. Imagine a situation where, depending on whether it's the state trying you on their own law or the federal government trying you on the state's law, as to how your rights are going to be adjudicated, and the sheer amount of abuse that is possible as a result of that choice. If you remember back in the line of Weeks cases, there was that concern as well, where the federal government would pick their venue for charging to get evidence in that they had been illegally gathering. If you went to the federal government, you couldn't do it, but if you charged in the states, you could. This is that same type of concern. In terms of other forms of litigation, it also opened up avenues of abuse by the citizenry. So let's say you lived in Pennsylvania and you had a contract, and in the way that you wanted to violate the contract, either by breaking or only partially performing or whatever the problem would be, in Pennsylvania, there could be a cause of action against you and you would lose. But if you ended up in a federal court, you had actually a much better chance of winning based off of the way those courts were interpreting a statute. It would encourage you to move to a different state before you decided to breach the contract. So long as you had moved beforehand, now you're a citizen of a new state, you have a slightly better chance in court, and the abuses continue. And as I mentioned at the beginning of the video, we end up with a situation the court also pointed out could happen, and that is forum shopping specifically. So in this case, Tompkins was a Pennsylvania citizen. The action happened in Pennsylvania. Everything occurred in Pennsylvania. But what did he do? He chose to file suit in New York. Why? Because in Pennsylvania, he was a trespasser. Under Pennsylvania law, he was a trespasser. So he probably would not have won in a Pennsylvania court. So he used forum shopping and this form of abuse to get into the federal courts, and he won $30,000. So looking at the totality of the situation, as well as those undergirding states' rights issues, that separation between the federal government and the powers granted to it by the Constitution, as well as the limitations that go with it, and the state's abilities to be independent outside of explicit constitutional control, the court found that the Swift Doctrine actually invaded states' rights. So when the appeals court refused to hear Erie's argument about the state law issue, the Supreme Court found that that was actually an error all on its own and reversed the case back down to the appeals court for further review. So what happened when it actually went back down? Because I enjoyed this part very much personally. On remand, the appeals court had to apply Pennsylvania law to this case. And as a result, Tompkins got thrown out of court. He didn't get his $30,000. He didn't get to pass go. It was done. He was out. And we ended up with what is called the Eerie Doctrine. What's interesting is it created something of a unique situation in our court system. As a general proposition, courts are not advisory bodies. You can't go to a court and say, how would you rule on this? What do you think? We don't do that in this country, and there's actually a case about that, which I will talk about in another video. But for purposes of the Eerie Doctrine, it is actually possible for federal courts to reach out to the Supreme Court of a particular state and get an opinion about the applicability of the issue and the law at hand, which makes some sense because the federal government isn't applying its own law, it's applying theirs. And why would we expect the federal government to be an expert and to be able to stand in the shoes of a different sovereign? But with that comes the underlying fact that for state law purposes, for the state courts, they don't really care much what the feds do with their law. It's not binding on them. The state courts may choose to adopt it. It's possible for them to do so, but they are not required. And that is Erie Railroad. And that is Erie Railroad. And I had to say railroad 3 times because I keep throwing a W in there and I sound ridiculous. So reach out down below and let me know what you think. Did the court get it right? Should they be applying state law when it's not actually their law? Or should there be some kind of federal common law that they can rely upon in the application of their own cases? But until we are together again, I hope everyone is well.